Good afternoon, and thank you for joining the Lawyers Committee for Civil Rights under Law. We are pleased that you have chosen to engage with us and our work to ensure that Black people and other communities of color have the voice, opportunity, and power to make the promises of this nation's democracy real. If this is your first time engaging with the Lawyers Committee, we sincerely appreciate your time and hope that you are compelled to remain connected with us and support our work. Today begins our first conversation in a series of virtual events which will occur throughout this year. Our focus today, Executive Disorder, how the Trump administration is weaponizing executive orders to dismantle civil rights, will be candidly discussed by our expert leaders at the Lawyers Committee and our special guests. Since his first day in office, President Donald J. Trump has issued over 60 executive orders, which has caused trepidation, confusion, and feelings of divisiveness. To navigate our discussion regarding the impact of these executive orders, we are joined by our President and Executive Director of the Lawyers Committee, Damon Hewitt, our moderator today and acting co-chief counsel, Darielle Rodriguez, and Shatora Roberson, Senior Policy Counsel for the Lawyers Committee. We are also pleased and honored to include our expert speakers, Jean Tom, partner at Davis Wright Tremaine, and also the President and Chief Executive Officer of the Association of Black Foundation Executives, Susan Taylor Batten. At this time, I welcome Lawyers Committee President and Executive Director, Damon Hewitt. Good afternoon, Damon.
Thanks so much, Keisha, and thanks everyone for joining us. These are sobering times. Many of you who know us at the Lawyers Committee know that we were founded at a moment of national crisis in this country. When civil rights fires were blazing, it would only get hotter, just days after the assassination of Medgar Evers, the days after George Wallace stood in the schoolhouse door to Black integration at the University of Alabama, an open defiance, an obstruction of justice, defying federal civil rights laws. We're seeing some of the same things today, at least in spirit. These are efforts to roll back the clock. These are efforts to ignore laws that are on the books. And these are efforts, frankly, to rewrite law. No president can do that with the stroke of a pen or with their mouth, but that's exactly what we have in progress today. You know, this Trump administration has been on a blatant warpath. And as opaque and with the lack of transparency that we've seen, some things are really crystal clear. One is that the effort when it comes to civil rights is to weaken the existing federal civil rights infrastructure. One of the chief ways that's happening is through the dismantling of civil rights offices upon which federal employees rely, but also those like OFCCP within the Department of Labor, which you'll hear about later, which actually has the power or had the power to exercise affirmative mandates upon private employers in terms of government contractors all throughout the country. That's your large defense contractors, that's goods and services, that's all types of contractors, a huge percentage of the federal workforce. That is something that Trump is trying to wipe away. But even as this weakening is happening, the other sinister side of the coin is the weaponization. To weaken and simultaneously weaponize is a bit of a Jedi mind trick, but that's exactly what's happening with an anti-DE&I executive order that directs federal agencies to find 9 targets each in the private sector, not just in government contractors, but throughout the private sector. Colleges and universities of a certain size, philanthropies, as you'll hear, of a certain size, which fund the work of organizations like the Lawyers Committee, grassroots groups, grass tops groups, what have you. Also, even public groups and associations like bar associations, state and local, and of course, publicly traded companies as well. What we're seeing is very dastardly. As we get into today's conversation, I want you to keep a few things in mind. Number one, much of what this administration is doing is contrary to law. We've already seen a number of actions and some early victories in federal courts, and hopefully there will be more, and you'll hear more about litigation we're involved in later in this program. The second thing is that pretty much all of the programs, conversely, that Trump and his administration are attacking are themselves entirely lawful. These are by and large not race exclusive programs, and even those can be defended in certain contexts. But these programs are simply things that companies are doing, that workplaces are doing, that schools are doing as part of their effort to actually comply with existing federal civil rights law. They're being told that efforts to comply are somehow illegal and that they have been for decades, which is patently false. But what it also means is when we see this preemptive compliance in the private sector, corporations dismantling DE&I initiatives, walking back commitments, even in their proxy statements, colleges, universities, K-12 school districts, what this means is that preemptive compliance is not required by law either. They're simply just walking away, some trying to curry favor, some simply out of fear, but this is preemptive compliance that simply is not required. Even as we defend the infrastructure in the courts and beyond, we actually have to wrestle with the fragility of the infrastructure we have. If it's somehow this easy for a single administration to try to rewrite the rules of the game, if it's somehow this easy for our erstwhile friends to walk away from their commitments, then what did we have in the first place? We have to look ourselves in the mirror as a civil rights community, as a community of concerned people. But more importantly, forward-looking is what we have to be. Even as we fight back, we also have to figure out how to fight forward. And what that means is not simply rebuilding what we feel like we've been losing. What it might mean is building something new and stronger in its place as this carnage starts to settle. Thank you for joining us once again today. I want to turn now to the person who will lead this discussion, my friend, my great colleague, who so many of you have gotten to know through her work at the Lawyers Committee, through her work at the Department of Labor, through her work at the Civil Rights Bureau in the state of New York, Darielle Rodriguez, our acting co-chief counsel at the Lawyers Committee. Darielle, over to you.
Thank you, Damon. It's a real pleasure to be here virtually with all of you. This, as Damon said, these are very difficult moments and times for us, and the Lawyers Committee has been in the fight for a very long time, since the inception of our organization in 1963 by President JFK. And our organization was created to combat systemic racism and discrimination faced by Black communities and communities of color. And it's a mission that continues to be very much alive today. We do our work by leveraging the resources of the private bar. And over the past 1.5 to 2 years, we have been working very closely with the private bar to provide support to nonprofit organizations and other entities that are figuring out how to navigate this moment and continue their very critical racial equity work. Today, we are joined by several guest speakers, including my colleague, Shatora Roberson, who is Senior Policy Counsel at the Lawyers Committee for Civil Rights. Shatora will first provide some context for the conversation and provide an overview of the 2 anti-DEI executive orders that we've been working so hard to push back against, including through litigation. We will then turn it over to Susan Taylor Batten, a fierce comrade and colleague of mine at APFI. Susan and I have been working very closely to provide advice and counsel to philanthropic organizations on how to navigate this moment. And I so truly admire the leadership that Susan demonstrates day in and day out. And Susan will discuss the impacts of the executive orders to the philanthropic community and the work that APFI is doing in this moment. We will then turn to Jean Tom from Davis Wright Tremaine. Jean is someone that I really look up to. Davis Wright Tremaine has been such an incredible pro bono partner to the Lawyers Committee. And Jean's group has deep expertise in providing advice to tax-exempt organizations. And it's advice that really complements the civil rights advice that we give to nonprofit organizations. So Jean, so incredibly grateful for all of the hours that your team has volunteered to support the organizations that we are serving across the country. Jean will discuss how to adapt your organization's practices, procedures, operations in light of the uncertainty coming from the federal government. So I will start by introducing Shatora. Shatora currently serves as Senior Policy Counsel with the Lawyers Committee for Civil Rights Under Law, with a focus on digital justice policy and racial equity policy. Previously, Shatora served as a Managing Policy Advisor at Tesla, managing state-level policy across the Northeast and Midwest. While at Tesla, Ms. Roberson advocated for issues including environmental justice, decarbonization, privacy, AI, and increased access to clean cars. She also led policy and social impact at Tesla's Gigafactory New York, launching multiple community resilience programs in workforce development for underrepresented communities and environmental stewardship. Before her tenure at Tesla, Ms. Roberson served as the Chief Diversity Officer for the City of Buffalo, where she developed regional policies for equity and inclusion. Notably, she utilized public-private partnerships to enhance the capacity of small businesses. Focusing on first-generation business owners from historically disadvantaged communities, she increased the City of Buffalo's utilization of small businesses owned by people of color by over 300% in just one fiscal year. Amazing work that you've done, Shatora, before coming to the Lawyers Committee. So thank you so much for being here. And I'll turn it over to you to share a bit more about the 2 executive orders.
Thank you so much, Darielle. I just want to start off by saying that, since January 20th, we've really entered a new frontier that fundamentally disrupts our nation's historic commitment to civil rights. And that war the war that's being waged is one of misinformation and rhetoric, and it's being cloaked by this so-called war on wokeness. But what's actually happening is a full-scale attack on our institutions and personal freedoms. And, in the wake of systemic and institutional oppression, thoughts and prayers just stop being enough. So diversity, equity, and inclusion was then designed to reject the status quo, protect Black lives, and create opportunity for all Americans, regardless of their race, gender, or socioeconomic status. And so when you hear the term diversity, equity, and inclusion, as a practitioner in this space on a macro level, I'm hoping that you think of this category as a practical application of civil rights. Things like workforce development programs that are targeted at low-income urban and rural communities, or the creation of an interdisciplinary unit within a police department to help individuals with mental health issues instead of criminalizing them. That is what diversity, equity, and inclusion truly means. But unfortunately today, I will discuss these 2 recent executive orders issued by the administration that have profound implications for these values within our federal operations and the private sector. The first one is entitled Ending Radical and Wasteful Government DEI Programs and Preferencing. I'll refer to this as the J20 executive order. It was issued on January 20th. And it mandates the immediate cessation of all diversity, equity, inclusion, and accessibility programs, and the termination of offices and positions, along with contractors across federal agencies. And there's kind of like 2 prongs to this. It's very vague. One is under whatever name those programs may appear. And the second is a little nefarious. It's to the maximum extent allowed by law. So these initiatives, these, DEIA initiatives have been labeled as wasteful and accused of misusing public resources. So the first executive order that this administration released on January 20th actually rescinded President Biden's executive order called Advancing Equity and Racial Justice through the federal government, which I'll refer to as 13985. And the thing about 13985 is that it really shows the extent to which diversity, equity, and inclusion impacts the entire country. And it says that the federal government's goal in advancing equity is to provide everyone with the opportunity to reach their full potential. And then equity is defined as the constant and systemic, fair, just, and impartial treatment of all individuals, including individuals who belong to underserved communities. And underserved communities in that executive order include not only people of color, Black community, Latino, Native Americans, Pacific Islanders, but also religious minorities, the LGBTQ plus community, people with disabilities, but also people living in rural communities and living in poverty. So the definition of underserved communities is foundational for ensuring that equity measures, they're not just symbolic, but substantial and reach all who are currently and historically marginalized or excluded. So a lot of people think that DEI is for those people, right? But it's for all of us, diversity, equity, and inclusion. The broad categorization of underserved communities under Executive Order 13985, it acknowledges the complexity of disadvantage that intersects race, economics, and geography. And so by erasing this definition and rescinding this executive order, we have, taken away a lot of protections for those communities. The second executive order, which I'll refer to as the J21 executive order, is called Ending Illegal Discrimination and Restoring Merit-Based Opportunity. The main distinction between these two executive orders is that the first one really focuses on the federal government and offices and positions within federal agencies. And this one really expands on beyond the federal government, as Damon mentioned in his opening remarks. So what's interesting about this executive order is that it recognizes and acknowledges the legal authority of the Civil Rights Act of 1964, but it simultaneously labels diversity, equity, inclusion, and accessibility programs within the federal government, private institutions, law enforcement agencies, institutions of higher education, and other industries as illegal. So that right there is a little confusing, right? And then the executive order is just overall kind of written in this propaganda-like language. It claims that these programs are, and I'm quoting, an unlawful, corrosive, and pernicious identity-based spoil system. So the reason why I started talking about the purpose of DEI and giving very specific, concrete examples of what that looks like is because when you hear language like this, it is designed to incite anger and hatred when the programs and purpose of diversity, equity, and inclusion does exactly the opposite of that. And so this executive order takes the J20 executive order even further. It applies it to the private sector, and it revokes additional executive orders and presidential memoranda dating back to the Johnson administration. So I'm kind of going to go section by this. Section 2 of the executive order focuses on overhauling federal hiring and contracting, and it mandates the removal of diversity, equity, and inclusion, and revokes those previous executive orders, including one that many people a part of this panel are very familiar with, which is Executive Order 11246. And subsequent executive orders that actually strengthened 11246. And the goal of doing this was simply to produce a disquieting effect on the American workforce and their employers. So the impacts of this executive order from the Trump administration impacts all Americans. Although the explicit language contained within the document, it calls out, DEI and affirmative action programs, the rescinded executive orders like 11246, which was specifically designed to strengthen, designed to protect workers in the federal government and federal contractors. It strips workers of those protections by prohibiting that would have prohibited discrimination for all federal contractors, allowed for pay transparency. Other executive orders that were rescinded from this within this document provided environmental protections for underserved communities and affirmative measures that guard against the discrimination within the workforce of federal contractors. And even so far as promoting diversity in national security agencies. So these revocations roll back rights for all Americans. But what we know for sure is that communities of color, especially Black people, those living in poverty, and those with disabilities, they will be the most negatively impacted by this section and this executive order. And then this is where things really become like the long arm of the law in Section 4. The title says it all. It's called Encouraging the Private Sector to End Illegal DEI Discrimination and Preferences. Interesting use of language with that word, encouraging, right? The Trump administration, through this section, plans to take the crusade on civil rights and diversity, equity, and inclusion straight to the private sector, making an example of people and institutions that do not obey the administration's stated rules. Targeted actions that are outlined in this executive order will be taken against specifically publicly traded companies, large nonprofits. Please note that large is not defined within the document. Foundations with assets in excess of $500 million, state and local bar and medical associations, and institutions of higher education with endowments in excess of $1 billion. So pretty comprehensive and unprecedented in its reach, and will be interesting to see how this all plays out. But we started to see some ways that they're addressing this specifically in education. Section 4B of this executive order also directs the Attorney General to submit a report that basically will outline private sector enforcement. And Damon alluded to this earlier, but this report will identify industries and practitioners within those industries to be targeted with potential civil investigations. The report will identify, and I'm quoting, strategies to encourage the private sector to end illegal DEI discrimination and preferences and comply with all civil rights laws. So, there's potential for litigation on the federal side and regulatory guidance. And then finally, Section 5 of this executive order also calls on the Attorney General and the Education Secretary to issue guidance to all state and local education agencies and institutions of higher education that receive federal funds or participate in the federal student loan program, to how to comply with the Student for Fair Housing ruling. That is interesting because they've already, the Department of Ed has released what they've called a Dear Colleague letter that misapplies the SFFA v. Harvard ruling in its application. And so we're starting to see some of these provisions coming to light and being rolled out. But that being said, these two executive orders in and of themselves, they also specifically talk about to the maximum extent allowed by law. So right now, there is a limit to the power of these executive orders, but we know that there has been legislation introduced. One massive piece of legislation was introduced in 2024 by then Senator J.D. Vance and Congressman Cloud called the Dismantle DEI Act, which would give additional force to these executive orders in their implementation. And we've seen smaller, more targeted messaging bills come out, one more recently called the DEI to Die Act. So there's a lot of fear mongering and leveraging of, this rhetoric in order to attack what they're claiming is unlawful DEI, but what's really a gutting of our institutions and civil rights.
Thank you so much, Datora, for that really helpful overview. And it will certainly ground the rest of our conversation. just to add a couple of things to that, to lift up sort of how we've been seeing this play out with the nonprofit organizations that we've been helping to support over the past year and a half or so. After the executive order was issued, the first one, there was language in there that talked about the termination of equity-related grants and contracts, as Chatora mentioned. And unfortunately, nobody really knows what that means. What do they mean by equity-related grants and contracts? Many nonprofit organizations that do work to advance equity, to dismantle barriers to equal opportunity, that receive federal funding, started receiving cease and desist notices from federal agencies asking them to stop doing their work as the federal government conducted a review to determine whether or not the executive order was applicable. So many organizations are currently really trying to figure out whether their federal funding is at risk, and they're spending a lot of time and energy developing plan Bs in case that termination is if that funding is terminated. Under the executive order, there are, I believe, the federal government agencies were given about 2 months to conduct their analysis to determine whether or not the funding should be terminated. So a lot of organizations are really, worried as they wait to get a final determination from the federal agencies that have been funding them. And as a result, we decided to move forward with filing a lawsuit. We very recently filed a lawsuit in Chicago in federal court on behalf of an incredible organization called Chicago Women in Trades. Chicago Women in Trades is an organization that receives various federal grants, including by the Department of Labor, to specifically to combat barriers faced by women who are underrepresented in trades occupations, including jobs like construction jobs. And as we know, not only are women underrepresented in the trades, Black and Latina women are severely underrepresented in those jobs. And these are good paying jobs that provide a pathway to more economic security, not only for themselves, but also for their families. So we have filed this lawsuit. There have been other, and we were joined by co-counsel Latino Justice, the National Women's Law Center, Chicago Lawyers Committee, and our fantastic pro bono co-counsel team at Kroll and Mooring. We are waiting to see what next steps in that case will be. There have been several other cases that have been filed by our coalition sister civil rights organizations, including LDF and Lambda Legal and Democracy Forward as well. And one of those cases did result in a nationwide preliminary injunction. That was the case that was brought by Democracy Forward. And that preliminary injunction is currently on appeal. So as part of our strategy, we have, as a coalition, filed multiple lawsuits in different geographic areas because we know that it's just really critical to ensure that we are addressing the full scope of impact of these executive orders on the communities that we serve. So I will pause there and then turn it over to Susan Taylor Batten. Susan, thanks so much for joining us today. I want to quickly introduce you. Susan, I learned something new by reading your bio. I didn't know that you used to work at USDA.
Oh yeah, I did.
So you have federal government work experience, which is, I'm sure, very relevant these days because USDA does such incredibly important work. Susan Taylor Batten is President and Chief Executive Officer of APFI, a philanthropic partnership for Black communities. APFI is a membership-based philanthropic organization that advocates for responsive and transformative investments in Black communities. Since joining APFI in 2009, Susan has led the organization's philanthropic advising and programming on responsive philanthropy in Black communities for foundation leaders, donors, and aligned partners. Batten came to APFI after more than 25 years of leadership experience in both the private and public sectors. Prior to joining APFI, Batten served as senior associate with the Annie E. Casey Foundation, a grant-making institution focused on child welfare. And in the public sector, Batten worked as a senior analyst for the U.S. Department of Agriculture, where she directed research and evaluation on food assistance programs. She also served in the government of D.C. as an analyst on initiatives supporting youth, children, and families. Susan, thank you so much for all of the work that you've done to advance equity for so many communities. And I will turn it over to you to just discuss the impact of these executive orders and prior challenges on philanthropies and the work that you're doing to meet this moment.
Yeah, thank you. Thanks, Darielle. Thanks to the full team of the Lawyers Committee. You all are doing the most important work right now. So just appreciate your leadership and your partnership. I want to start just by talking about some trends or themes that we are seeing in the field of philanthropy. And then there are 5 that I'll go over very high level. The first, it's important to say that some foundations are just clearly moving ahead, regardless of the executive orders, regardless of the challenges that have come before them. Clearly, foundations that are focused on racial justice and social justice in this country are moving ahead. Many of these are smaller, more progressive foundations, as well as those that have a real clear alignment between equity and the missions of their philanthropic entities. So clearly, some foundations are moving ahead. We want to see more in this area, though, and I'll talk a little bit about other trends. It is clear, the second theme that I would lift up, that there is in this moment a real search for clarity and solutions to counter the attacks. There are a lot of gray areas for philanthropy and for nonprofits, I would say, particularly in the legal landscape. Folks are just not clear what's legal, what's not legal. And again, we know that that's part of strategy coming from this administration, is to sort of build a level of confusion that ultimately slows down investing in equity and justice. And so that is why programs like this one are clearly so important. And Darielle and I have been joined at the hip probably for the last year almost, just working in the field of philanthropy to bring clarity, to address some of the misinformation. But every program that I'm on, we see 100, 200 registrants, because folks are just trying to figure out sort of what's legal, what's right, and how to move forward. The third point is a concern of ours at AbbVie, and that is, I believe, colleagues, the philanthropic sector has gotten pretty quiet. I would say unusually quiet. Philanthropy has a powerful platform. It's not just about the resources that foundations have, but it is their pulpit and their voice to bring attention and focus to important values and principles. And particularly these last executive orders around eliminating illegal DEI, I think has really had a chilling effect and done a lot to mute foundations that usually are a lot more visible and vocal. We know that executive order that does charge the Attorney General to come up with what we call the hit list of foundations, has created a sense of fear. And, we are pushing the field of philanthropy to understand that being quiet actually doesn't reduce risk in terms of, opposition coming after one's resources or grantees. But that is a concern that we have, is the lack of vocal advocacy from foundations on issues of racial equity and justice and opportunity for all people. The fourth theme or trend, I would say, again, very disturbing and a healthy debate in the philanthropic field, is that we are seeing foundations, I should say, pulling back on language. Again, we know that there are efforts within the administration to flag certain words, equity, justice, right? We are in a heated conversation in the field of philanthropy about the importance of speaking truth and speaking truth to power. Dariella, I say often wherever I speak that funding Black people is not illegal. We can say Black, we can say Latino, we can say equity. And again, I think for the purposes of trying to protect the work, we do see some philanthropies actually scrubbing websites, scrubbing proposals of grantees, and using proxies for race and equity. And again, it's a healthy debate, and there are folks on both sides, but we believe it's important, again, not to mute our voices and to continue to talk about race and racial equity. It is not illegal to do so. And then the fifth sort of trend I would share clearly, unfortunately, we are seeing rollbacks on funding portfolios specifically investing in racial justice and racial equity. Now, some of this, and Damon, you mentioned it in your opening remarks, it's like, 2020, we thought we had a groundswell of resources, particularly to invest in Black communities, other communities of color, really since 2020, but definitely since the Supreme Court decision and these executive orders, we are seeing portfolios go away that focused on racial equity and justice. So it makes us question, what did we have in the first place? Many commitments that were made in 2020 have completely folded as a result of the push, the anti-DEI push, and newer funders, I would say primarily, and some in the corporate space, of course, corporate philanthropy, pulling back portfolios on racial equity and racial justice. So high level, those are some of the trends and sort of the responses that we see in the sector. Darielle, I want to use my last few minutes to just give some guidance, particularly to foundations that are listening in today. In 2023, ABFI, along with our partners, Hispanics in Philanthropy, Native Americans in Philanthropy, Asian Americans and Pacific Islanders in Philanthropy, set up a body of work called the Racial Equity Advancement and Defense Initiative, or we call it READY for short. And I can talk more about the work of READY, but we are about to roll out a set of transformative actions that we want philanthropy to take on in this moment, given the executive orders and challenges before them. And they're really in three areas. They are about transforming foundation boards. We think we have to talk directly to foundation boards in this moment, transforming relationships between foundations and grantees in particular, and transforming the field at large. So let me start in terms of transforming internal structures and governance specifically. And again, I'm talking to foundations primarily. We are asking funders in this moment to work on structuring both the composition and the focus of their board of directors on supporting what we call race-explicit grant making. Foundations that are actually doubling down in this moment are doing it because they have directors that are behind this work, understand this work. They have shared perspectives, definitions, and point of view about what racial equity is, the fact that it's not a zero-sum game, people that understand DEI. And so we're really asking foundations to sort of focus in on the structure and focus of boards. Also to build explicit learning agendas around race-explicit grant making. Now, this is a best practice that should be in place anyway, as it relates to foundations in the US that want to see good opportunity for all people. But now it's really important to deepen the learning around race-explicit grant making within philanthropy, understanding what it is, how it's mission critical to the work that your foundation does, and how the work of racial diversity, equity, and inclusion is being weaponized, and actually who's doing that. We think it's really important for foundation, particularly boards of foundations, to understand. And then the last point around transforming internal structures and governance, and I think we spend a lot of time on this in the field, we are asking boards to name and own your appetite for legal risk. One is to seek legal counsel. That's the first thing we're saying to colleagues, seek legal counsel. And also, we had a great conversation at our board at AbbVie a couple of weeks ago about differentiating between legal risk and liability risk. And they are different. And to really wrestle within foundation boardrooms about whether or not we are concerned about getting sued, because we know anybody can be sued in this country, or are we concerned about being found liable, actually doing something illegal? And so sort of that interpretation and wrestling with that, really, really important. The second transformative action has to do with, as I said, transforming relationships with grantees and funders. We are asking three things in this area as well from foundations. One is to reach strategies on what we call the unshakable truth, that race-conscious investing is good for everyone. This is not just about protecting Black people or protecting Latino people. We know that race-conscious grant making is good for everyone. We have shared fate in this country. What happens to communities of color affects white communities and the like. And so we're asking foundations to evaluate and elevate data to show that addressing equity for one group of people actually benefits other groups. And there's a lot of research and examples from philanthropy that actually can be made. The second point, get creative with funding strategies. We're asking folks to lean into trust-based philanthropy and provide gifts versus grants with less strings attached. And then the third is to build relationships beyond the transactional, invite grantees and discussions with foundation staff, and to help build communities of practice for foundations and nonprofits. This is a moment, Darielle, where I believe nonprofit organizations, foundations as well, have to be in community, have to be in communities of practice. The concerns that I get, the calls that I get from Black-led nonprofits are those that aren't connected to information sources or peers about how to navigate in this moment. And so we're asking foundations to ensure that every organization that is fighting the good fight around racial justice has a community of practice to feel safe in. And then the last, I'll stop here. This is a set of transformative actions around transforming the field of philanthropy that we're asking foundations to really focus on in this moment. Funding narrative change is absolutely essential. Strategic communications, colleagues, and campaigns that can help shape accurate narratives about equity and to counter misinformation. This is the time to put more resources, more than ever before, into narrative to sort of fight the push against DEI. We need to uplift the positive vision that philanthropy has for America, and we have one, and we need to resource that in terms of narrative and strategic communications work. The second point under this transformative action is to be vocal about race consciousness. Again, it's a note that I picked up from Stacey Abrams. She said we have to be loud about our work in the area of racial equity and racial justice to legitimize the work, right? To normalize the work, to take back the narrative. And then the last point in terms of transforming the field, it is time, philanthropy, to put more money out than ever before. Philanthropy has demonstrated in times of crisis that we can cut red tape, we can cut bureaucracy, and we can move resources to the ground. Organizations that are the critical groups in terms of infrastructure for change in America. And so we are asking foundations to consider increasing their payouts in this moment. We've seen a number of foundations say they're going to go above the required 5% payout. Increase your payouts. We're asking foundations to consider building endowments for nonprofits, not just holding endowments themselves, but to endow nonprofits that are doing this important work around justice and equity for people. And when we think about moving more money, again, seismic proportions of money, we are sort of lifting up areas of civic engagement, get out the vote resources, legal support, security, including physical security, cybersecurity, peer support, and mental health and wellness. Again, these transformative actions are about to be released by the Ready Coalition. And I'll stop there and I look forward to the conversation.
Thank you so much, Susan. That was fantastic. I have I took down a lot of notes while you were speaking, and I'd love to ask you a couple of follow-up questions. I love the point that you made about really now is the time to double down on race explicit grant making. I was wondering if you could speak to, I had originally framed this question as, can you speak to the importance of funding racial equity work in the current environment? But I'm going to rephrase it a little bit, because what we're seeing is that a lot of nonprofit organizations doing equity work that receive federal funding are at risk of losing that funding. And so what that means is that they may be at risk of having to lay off staff, having to close their doors, et cetera. So can you speak to the risks of not funding racial equity work or backing away from funding racial equity work in this current environment, given what we stand to lose with these various attacks that, quite frankly, were already happening even before the SFFA ruling, right? But that really picked up speed after the SFFA ruling. And now we have this avalanche of executive action by the current administration. Can you just talk about truly what is at risk here for the communities that we serve?
Yeah, there's so much at risk. I remember someone saying several years ago, what do you have to lose? Speaking to Black folks, and it is very clear what we have to lose right now. But it's important, as we know, Darielle, that we are working in a time of attempted erasure. You know, whether we're talking about book bans or attacking critical race theory, the attempt to sort of wipe the history, the true history of this country, sort of off the map. And we already have a very fragile infrastructure for social change in this country. I actually think it's a direct result of the disinvestment, or what we call philanthropic redlining, of Black-led organizations that are about building political and economic power for our people and others in this country. So the infrastructure is already very fragile. What we have to lose, I think, is this aspiration of a multiracial democracy without investing in ways in which, again, we have not invested before. I think that promise of America, this tested experiment of a multiracial democracy, does not survive. It just doesn't survive.
Thank you so much, Susan. And the other point that I jotted down that really resonated with me was the point that we have to take back the narrative, right? We have to be loud about the need to continue this really important work. And I think instead of diluting our mission and the work that we're doing, we have to become more specific. We have to become more focused. We really have to figure out what is it that we're trying to address, and what are the most responsive programs that we can develop to address these particular barriers confronting our communities, right? Like right now is not the moment to dilute. Correct. It's the moment to become more focused. And I think sometimes organizations are confused because they're, as you said, they're getting this messaging that they need to scrub their websites and not talk about racism. And do you have any guidance, advice, support, resources for organizations that really want to stay committed to their mission of advancing racial equity in terms of how to talk about their work in this moment and continue to do so in a way that is impactful, that continues to have impact for their communities?
Yeah. Thanks for that. The good news is that the resources are organizing. I mean, and after the Supreme Court decision, we were scrambling just to ensure that grassroots racial justice, Black-led nonprofits had access to information, tools, and resources. And so one, Darielle, I would mention is, as I said earlier, the Racial Equity Advancement and Defense Initiative actually has organized a resource bank for nonprofits and small foundations. And there you will find, colleagues, resources of all kinds, tools, materials, articles, web programs like this one, virtual programs. You can go to our website at www.adfe.org and click on affirmative action, and you'll see the resource bank. That is a evolving and live resource bank that we, again, want to offer nonprofits and small philanthropies. There are a number of trackers, I think, that are very helpful. As it relates to nonprofits, I would just lift up and shout out the National Council of Nonprofits. They're doing amazing work. They're bringing suits themselves, but they have a tracker specifically designed to look at the executive orders and their impact on nonprofit organizations. And so just to offer that resource, you mentioned Democracy Forward. They've got amazing resources as well. They've got a executive order response center that I have found very helpful. It actually helps lay people like me that are not attorneys understand what's happening in the legal landscape. So those are specifically for nonprofits. For foundations, I do want to just shout out Funders for Justice. Funders for Justice is doing amazing work around what we know about how authoritarian regimes have attacked philanthropy in other places around the world. And this is when we do have to lean into international sort of partnerships and help and support. So I would suggest that funders and nonprofits check out Funders for Justice. We also finally have a series for foundations called the Sankofa series. Every month, we are convening 50, 60, 70 foundation CEOs to talk about what's happening in this moment. So the message here is that you are not alone, and get in community. Get in community. Yeah.
Thank you so much, Susan. Really appreciate it. Okay, we will now turn to Jean Tom. Jean is a partner at Davis Wright Tremaine. She is the chair of the firm's tax-exempt organizations practice group, and she co-chairs the firm's Attorneys of Color Affinity Group. So Jean, when I pulled up your bio on your Davis Wright Tremaine website, I loved your byline on your bio, and it says that you have the privilege of advising people and organizations that are changing the world. I was surprised to see that, but not surprised to see that, because I think that's why the Lawyers Committee has been able to develop such a wonderful partnership with you all, because our orientation is very much aligned in that way. Jean is a trusted advisor to philanthropists and mission-driven organizations. She provides practical advice that helps clients navigate complex laws so that they can focus on mission and achieving social impact. Jean's clients are a diverse mix of philanthropists, social entrepreneurs, public charities, private foundations, social welfare organizations, and trade associations. Her clients focus on fields ranging from educational to social, racial, and economic justice, health, scientific research and innovation, arts and culture, environmental conservation, religion, and animal welfare. So Jean, thank you so much for taking time to join us, and would love to hear more about the issues that you're seeing, how organizations are adapting to this moment, and any guidance that you may have for our listeners.
Sure. Thank you so much for having me here today. I mean, I think in noting all the issue areas that my clients work in, what's kind of striking to me is how every sector is touched right now, and in a negative way, I would say, by what's been unleashed by this new administration. And so I just want to take a moment and acknowledge what a difficult and fraught moment it is for everyone in this sector. Just staying on top of the dizzying pace of the executive orders, and then the injunctions that have come out to stop them, trying to understand and interpret their effects and figure out what to do in this moment has been a real challenge, to say the least. And also we're seeing real devastating human impact already. Since the executive orders were unleashed, groups have been summarily notified that their federal grants are being cut off. And, or they're being told that, their research money is going to be capped at 15% overhead, which isn't enough to keep the lights on. And groups are already having to lay off staff, shut down programs, and cut off services to needy populations. And so, it's truly been a devastating time for the sector. And, even for those who aren't recipients of federal funding, I think we've talked about this, the uncertainty around what is legal legal, what is illegal, what's going to trigger a lawsuit or an investigation. It's really quite paralyzing. And because what the language of the executive orders is so sweeping and vague, nobody knows if they're covered or not. And so it's just been a time of chaos and uncertainty. And perhaps that's the point. But it certainly has been chilling lots of legitimate, legal, important activity. And so, what I want to first say is, what do we do in a moment like this? I want to echo what everybody's called for, which is, community and collaboration, right? Just to stay on top of this dizzying pace, we really need to lean into each other. And so I really want to thank the Lawyers Committee for bringing us all together in this program and for highlighting all of the resources that are out there. That is how we're going to get through this together. I think, one question that people are really kind of interested in is, if you are a recipient of federal grant funding and you've received one of these notices that the funding is being paused, what can you do in this moment? Well, I've been leaning on my government contracting colleagues for advice, and they have a number of really helpful, practical pieces of advice. One thing is, if you don't know, or if you have received one of those notices from your federal grants manager, reach back out to them. So, there have been a couple mentions today of injunctions that have been recently put into place as of a week or two ago. There's several TROs and then a preliminary injunction on the federal grant and federal funding pause. And so those have been blocked, most recently nationwide by Judge Ali Khan of the District of Columbia circuit. And so our federal contracting folks have recommended, to write back and push back on to your grants administrators and say, we've received this notice that you have paused our grant or our award because it no longer furthers the agency's priorities. But to say, as you're aware, as of February 21st, Judge Abelson, so there's also the other preliminary injunction that blocked several portions of the DEI executive orders that Shatora went through. And one of the provisions that was blocked was the termination provision, the cutting off of the funding because they are assessing that it is not prioritizing the administration's priorities. That is actually enjoined right now. So to push back and say, that if they're trying to terminate your grant on that basis, as you know, the injunction has declared that that's likely unconstitutional. And so that you respectfully request that the grant be restored. And to be reinstated. So anyhow, that's one practical step you can take at this moment, and to seek their written response, because that's the current state of play right now. So be in contact and in written communication with your grants manager, because that funding should be presently restored under several injunctions. Another thing that my colleagues have recommended is also document your costs. Document the damages. So, if you are, having to incur storage fees, if you are not able to pay your subcontractors or subrecipients, document all of that. There may be the opportunity to seek recompense down the road, particularly given if funds are being cut off summarily, in violation of these injunctions. So that's another thing. Make sure you're documenting all of that. because there may be the opportunity to file claims down the road. Another thing is to communicate with your subrecipients and also try to keep them apprised of what's going on. Another thing is to talk with your outside non-governmental funders. As Susan alluded to, there are certain members of the philanthropic community who have, affirmatively said, we're going to increase our payout, we're going to increase our funding to the field right now because we recognize this is a crisis, that this is existential for many nonprofits, and they will go out of business if they are not supported and bridged through this moment. And so there are a number of funders who are thinking of creative ways of resourcing the field right now. Advancing funds. Say they had a multi-year grant, maybe advancing all the money right now, or releasing restrictions, or offering kind of bridge loans at 0%. So there are creative ways that, if you have a strong relationship with a funder and, you're going to not be able to meet payroll at this moment because your federal grant funding is frozen, talk to your funders and see if you can figure out creative ways to bridge that gap. So those are just a couple of things to do if you are faced with one of these shortfalls in the present moment because of the chaos and the rapidly shifting federal grant making landscape. In terms of other actions, I want to echo a lot of what Susan said. I think every nonprofit needs to kind of evaluate their own risk profile right now, and that's going to depend on, how much federal funding is at risk. It's going to also depend on your mission and how important, the kinds of so-called risky activities that are to your mission. And then it's also going to really depend on your board's level of risk tolerance. I think, Susan talked about legal risk and liability risk. Those should be board level conversations your organization is having right now. And, maybe you're one of those organizations that says, you know what, this is key to who we are. This is key to our mission. We're willing to go to the line, and, we're willing to put our toes over the line, bring on a lawsuit. This is too important to us. We are not going to back down. So, that might be where your organization stands, and you can make plans to set aside a legal defense fund, war chest, for the litigation when it comes. But so that might be where you're at. You might be on the other side of the spectrum. And I will say, there are groups that are continuing the work, but are doing it more quietly, and that is sort of for your organization to determine where your level of risk is. So have that conversation. I will say, though, both on the corporate side and on the foundation side, I liked what I heard Forward Together Foundation's president Deepak Bhargava say, which is courage is contagious. And so for those who are taking a stand, it is really heartening for everybody else in the field to see their leadership and to see their courage in these moments. So it's really helpful for groups that are willing to stick their neck out at this moment. There are other risk mitigation techniques, and it does feel terribly Orwellian right now to have to sort of think about changing words and words you can and can't say, but there are shifts that folks are making to reduce legal liability if they still want to engage in race conscious work. Professor Kenji Yoshino has talked about shifting, from cohorts to concerns. So say you want to resource BIPOC communities right now, or provide fellowships and scholarships, and this we've seen in all sorts of different fields. Those have been the target of litigation from right-wing groups, alleging that they violate anti-discrimination laws because they're exclusive to certain races. To slightly shift the criteria for those programs to, rather say it's only available to BIPOC leaders. It is available, your criteria then shifts to people who have a demonstrated history of serving the BIPOC community. And with that shift, that has led to the settlement or the dropping of lawsuits. So, that is one risk mitigation technique. True, it is giving something up. It is giving up the ability to say we are just resourcing organizations with BIPOC leaders, but it does reduce liability risk, and so perhaps that is a trade-off that is worth it. I know that's something that's being discussed a lot in the philanthropic community. I think there are a number of other things to do, but I think also what's really important is being in touch with your legislators and gathering stories and telling stories about the real impact that both of what the key kind of ongoing racial justice work, how important it is, and the sort of devastating impact of the rollbacks, but also the devastating impact of the cutting of federal grant funds, and communicating with your legislators, telling those stories so they are aware and can bring that to bear in Congress. So those are just a couple of the things that I am working with my clients on at this moment.
Thank you, Jean, so much. There are two questions that I had for you, and one sort of goes back to a point that Susan made in terms of potential practices to explore in this moment, particularly for philanthropy. And Susan mentioned that philanthropy should think about different ways to engage their grant recipients, right? What are ways that they can perhaps strengthen the relationship, increase trust? And I think Susan also mentioned trust-based philanthropy. Can you speak a little bit more about trust-based philanthropy? I feel like, I am not a philanthropy expert, a grant-making expert, but trust-based philanthropy is something that I started to hear more about after the rulings in the Fearless Fund case. And I'm curious to know whether trust-based philanthropy is something that your clients are exploring in developing, and whether that might be a way to further minimize potential liability while advancing racial equity work and continuing to have.
Yeah, thanks, Darielle. Yeah, no, it's interesting because trust-based philanthropy has been this sort of movement over the last, I'd say, 5 to 10 years, and really kind of, I think, took hold during COVID because, I think the whole overarching idea is to change the power dynamics between philanthropists and grantees or nonprofits, to really say, well, the power shouldn't be held solely in the hands of the philanthropists with the money, but really, they are there to partner with and resource the experts who are the nonprofits in the field doing the work. And so really trying to think about ways of lifting the burdens on the nonprofits doing the work, lifting restrictions. So there's a real emphasis on unrestricted general operating support for nonprofits, reducing things like, regular reporting, permitting nonprofits to submit reports they wrote for another funder, perhaps, just making it so that it is easier for the nonprofits to do the critical work they're doing every day is sort of I would say writ large, one of the tenets of trust-based philanthropy. So that has been arising as a stream over the last 5 to 10 years, but it's kind of interestingly dovetailing with the moment right now that we're facing with all of the challenges to race-based philanthropy because of Section 1981. So for those of you who don't know, Section 1981 is a civil rights statute that prohibits discrimination in contracting between private parties. It was actually passed to try to provide Black citizens with the same rights to contract as white citizens, but it has been somewhat turned on its head a bit with the recent Fearless Fund decision where Ed Blum's group sued the Fearless Fund, which was a group that was trying to resource Black female-owned companies, which receive 0.001% of the VC field. So trying to make a difference in rectifying that underfunding of that community, they had a special program where they provided $25,000 strivers grants to female-owned companies, Black female-owned companies. And Ed Blum's group came after them and said that is a violation of Section 1981, which prohibits discrimination in contracting. Well, the 11th Circuit had a preliminary injunction in favor of Ed Blum's group, but then the case was ultimately settled. So we don't have a final decision there. But the interesting question that was not fully adjudicated there is a grant, is a philanthropic grant or gift a contract under Section 1981? Because if it's not, it does not. It is not subject to the anti-discrimination laws in the way they're being interpreted under Section 1981. And so, and there's also a stronger argument that if it is just a gift, there is a strong First Amendment right to give to whoever you wish to. And so, well, this question is yet to be litigated, but the 11th Circuit did touch on that. Unfortunately, the Fearless Funds agreement said this is a contract. And so they did not have the ability to argue that it was outside of the ambit of Section 1981. However, I think the way I think about what distinguishes a contract from a gift, it is whether you have kind of bilateral obligations. Does the grantee have contractual requirements to perform certain things in return for their grant? The more you lift those obligations, the less it looks like a contract. So the more it's just a kind of, unrestricted gift from philanthropy to the grantee, arguably that's not a contract under Section 1981. And so query whether that gives you more of an opportunity to channel your gift to whichever organizations, communities, scholarship recipients you wish. And so that's one reason, that's another risk mitigation technique perhaps right now, is to lean into more trust-based, unrestricted, general operating gifts to grantees.
Thank you. Super helpful. And then the other question that we get a lot is, can organizations continue to collect demographic data for purposes of informing their race-conscious programs' impacts? And I'm curious to know your thoughts there.
Yeah, well, and this is where I rely on some of my employment colleagues, who are very steeped in sort of civil rights laws. My understanding is there is no prohibition against collecting the data. And tracking your own impact. I think what is being challenged now is when you use the data, the demographic data in decision making, that might exclude other groups. But if you are looking for the impact of your funding on the communities that you're serving, there is nothing currently in the law that prohibits you from collecting it if you are not using it in decision making in that fashion.
Thank you so much. Wholeheartedly agree. Demographic collection and analysis is just so very important to ensure that the programs that we are developing to serve our communities are having impact, and to help inform whether those programs need to be updated or strengthened, et cetera. So really appreciate that. I think that is all. I'm going to check in with Keisha to see if we have time for some additional Q&A. I know we received questions from our audience members, and if we have some time, I'm happy to share some of those questions for both Susan, Jean, and actually for Shatora as well, if we have a few minutes.
Yes, we do.
Okay, amazing. So why don't we bring everybody to the screen? Amazing. Okay, I'll start with Shatora. Shatora, what should current federal civil rights attorneys and policymakers do to ensure civil rights violations are heard and pursued in this moment?
Yeah, so it goes without saying that we are living in unprecedented times in terms of the respect and honoring of the rule of law. We've never seen an administration transact in this way. And so a couple of things just to kind of like build the foundation for this is that we're still in the flood the zone phase of whatever this the ultimate goal is here, which, is yet to be determined, but I think we all have a pretty good idea of that. So we know that the tactic is to overwhelm everyone with the amount of kind of edicts and misapplication of the law. So that's number one, and number two is to appreciate that although this is happening quickly and being done according to a very specific plan, the implementation in and of itself is quite sloppy. And so, we are building the ship and flying it at the same time. So just starting from the grassroots, and then we'll get to the grass tops. Number one is do not underestimate the power of civic engagement, especially when it comes to course correcting. We've seen this happen a number of times, especially when it came to things like the travel bans and things like that in years past, and how because of outcry and civic organizing, we did course correct and things were reversed in that manner. Number two is that the goal right now is to slow everything down. The flood the zone tactic is meant to overwhelm and kind of disable us from knowing where to go and confuse us from where to focus our energy. So stay focused on what your particular mission is, number one, and be vigilant about that. I've been on a lot of calls, and I might be misquoting, but I believe it was Damon who said that we're in this for the long haul. Post George Floyd, we saw a lot of a lot of early gratification for our efforts, and global outcry for what, as Black people, we've been experiencing for generations, but what the world finally saw when it came to the murder of George Floyd in cold blood. But we're in a different phase now. We're a bit desensitized to what we're a bit desensitized to these civil rights violations, and what our rights are as Americans, and just what human rights look like writ large. So that being said, we've seen a kind of reversing of sentiment globally, and a cooling of people's passion for this. So we have to be in this for the long haul. And that means doing things like keeping the pressure on your elected officials, telling them that, as we see the rescission of certain executive orders, we should, be moving to codify them, executive orders like 13985 and 11246, and also the reintroduction and sponsoring and co-sponsoring of bills that advance and protect our civil rights, like the John Lewis Voting Rights Advancement Act, the AI Civil Rights Act, the George Floyd Justice and Policing Act. So we know that we're in a precarious situation with who is in the majority in Congress right now, but continuing to push and making sure our voices are heard, number one, on the streets. If we're quiet, Jean brought up the fact that they have to know specific examples of how this is impacting lives. That is extremely important. And we've heard this specifically from lawmakers in leadership across the board. And number two, just making sure that we're continuing to put out good legislation, whether or not it's going to sail through and, make it into law. That's not the point right now. The point, number one, is to make sure that we are getting that message out there. And also, finally, we do have resources on the state level, and we can absolutely engage our legislators on the state level to help push bills that will help to preserve our civil rights on the state level. We don't want a patchwork. We don't want to see the dismantling of our universal civil rights on the federal level whatsoever. But engaging on the state and even local level is also a very effective way to help preserve these things. And finally, it goes without saying, but I'll say it anyway. As you and Jean have mentioned, litigation is extremely effective, and these injunctions and future decisions will really be the bulwark of how we slow this train down and help to preserve our rights. So big shout out to all the litigators. I've thought about how the Lawyers Committee was formed in its inception, and it's like, they were looking into a crystal ball and knew that in the future litigation was really going to be the final frontier. And so, continue to support organizations and the private bar that are focused on that.
Thank you, Chisora. Yeah. All of the points that you made are such powerful ones. And I'm going to sort of combine a couple of things that I heard you say, which is we can't stay quiet, which is a message that we heard from Susan and Jean, right? And the lawyers have to speak up. I saw the ABA put out a really strong statement, I think just maybe yesterday, and they've put out a few statements. So we really need lawyers to speak up in this moment too, to support the rule of law. I'm going to invite all of you to respond to this question. I think something that folks sometimes struggle to understand is that executive orders are not laws, right? And sometimes there's this misunderstanding that executive laws are changing existing laws, or that they are amending existing laws, for example, civil rights laws. And in fact, the opposite is true, right? They do not change our existing laws. They may undermine the protections that are available under those laws, right? But they're not changing existing laws. So for example, something that we say over and over again is Title VII is still on the books. Title VII requiring employers to not discriminate, to ensure safe environments for workers, that is still on the books. So, and as we've discussed, some of these executive orders, many of them are unlawful, unconstitutional, right? So not only do they not change the law, many of them are unlawful. So I think that is something that message is very important to get out to the public. Do you have any thoughts on how to sort of make those clear distinctions for the public? Or can you talk about ways that you've been making those points to the communities that you serve or to your constituencies or members or clients?
Yeah, I'll start. I mean, I think it is a fine nuanced point, right? And it's sometimes hard to make because the executive orders run around with this sloppy language saying illegal DEI. But actually, if you read the fine print, it says illegal DEI programs that violate federal anti-discrimination law. So really what they're saying is that programs that violate federal anti-discrimination law, which has not changed through the executive order, are what are illegal. Well, that was the case before the executive order. So, what they've done is just muddy the waters. But I think that is just the point we try to make, which is that, federal anti-discrimination law is the statutes, and then the sort of interpretations of them. And those have not changed. It's really just, what they're going to try to investigate or use the power of the federal purse to sort of condition, whether you get money or not. But still, the ultimate law that determines whether or not you are violating civil rights laws has not changed through the executive order. So, it's a little bit of a fine point, but we do just try to emphasize that.
You know,
Susan?
I would say, Darielle, as a layperson, I might be the only non-lawyer on this program. People do not know. And so, we need the help. You were just talking about lawyers speaking up. We need the help to ensure that the misinformation that is, purposeful, unfortunately strategic, and working in some instances, given its chilling effect. We need attorneys by our sides in community. It's why we talk about at ADFI the importance of investing in strategic communications. And I will just also use this opportunity to lift up the importance of investing in community and neighborhood-based media. We are extremely concerned, again, about existing sort of known news channels and sources facilitating the misunderstanding about executive orders. And again, speaking to foundations and investors, sort of how we build credible sources of news, factual news, right, that reach everyday people is critically important in this time. So we've got to pour resources into that and put our heads together around that.
Thank you so much. Any closing remarks so that we can then turn it back to Damon for his final words? I would love for each of you to leave us with your parting thoughts or message.
No, I'll jump in. Again, thank you for this opportunity. I want to just speak to Black-led nonprofits at this moment. I understand the concern and the fear. Would encourage organizations to seek legal counsel from groups like the Lawyers Committee that have pro bono supports and resources, to understand and know that the legal landscape is navigable. Foundations can navigate the landscape. And the last thing I'll say, I said earlier, just know and understand that funding and investing in Black people is not illegal.
Yeah, there's so much to say, but I love where Susan ended. I mean, I think, the work you do is so important. Stay in the field, keep doing the work you're doing. We will get through this. We will get through this together. I think that we lawyers are here to hopefully answer your questions and, hopefully lower your temperature. I've joked, that some people were talking about this time as, how not to lose your minds or your tax exempt status, right? But, we all need to engage in a lot of mutual support and care, but we will get through this.
I'll just say, continue to show up. The more that we try to, make a difference online and not in person, the more easily we'll be divided. And so, this is real life. This is happening right now to all of us. And so anybody who wants to participate and preserve, what our ancestors have fought so hard for us to get here, continue to show up and don't let what's happening online only be your reality.
Thank you so much to the three of you for your incredibly invaluable contributions today. I will turn it over to David.
Wow. Thanks so much, Darielle. This is such a rich dialogue. I've been here taking copious notes, and I just appreciate these great colleagues, you, Darielle, Shatora, Jean, and Susan. And I should mention that I'm a proud board member at ABFI, a philanthropic partnership for Black communities, which has just done such important work. You heard so many gems today. You heard continue to show up, speak out, be vocal, and leverage our collective voice and reputational capital. You heard that investing in Black people is not illegal. Investing in Black communities is not illegal, no matter what anyone tries to say.
Mhm.
Also, don't do the enemy's work for them. That's actually something I've heard you say before, Darielle. That's the preemptive compliance. It's so difficult. Organizations, companies are in such a difficult situation, but the more you retreat, the more the other side wins. Remember, when they say they're anti-DEI, they're saying they are against diversity, equity, and inclusion, which really means they are for racial isolation. They are willing to tolerate gross inequity, and they are for racialized exclusion, or put another way, resegregation. That's what is happening. That's what's at stake. We do believe that together we can create the good trouble that the late John Lewis talked about. We know at the Lawyers Committee we can't do it alone. As much as we have framed, I think appropriately, the fool's errand of what's happening in terms of the challenges to diversity, equity, and inclusion, that fool's errand is doing real damage. And so that means we can't do it alone. We partner with so many of the organizations that you heard about today, especially in litigation alignment, because the cases you've heard about and you've seen, including the one that we filed, are part of a collective wave. You're seeing different types of organizations and communities impacted. You're seeing different types of defendants as federal agencies. You're also seeing these cases filed in different federal courts. That is not by mistake. This is because we're aligned in trying to cover as much appropriate ground as we responsibly can. We also need your help, whether you're a lawyer, whether you're connected to the Lawyers Committee Pro Bono Network, whether you're a professional who's just concerned and cares, whether you're a supporter of the Lawyers Committee. There's a role for everyone to play in creating that good trouble. I want to personally invite you to remain connected to us at the Lawyers Committee, to support and invest in our work and the type of work that AFI does as well. We are organizations that are built for turbulent times, especially us at the Lawyers Committee. We're a nonpartisan organization, but we understand the political rhetoric and the narrative that's at play here, and we're willing to dig into that as we appropriately can. I want you to join us and learn more about our work. You can visit our website at lawyerscommittee.org. That's lawyerscommittee.org. Again, thank you for my colleagues who joined us. And again, thank you to you. Together, we will be in this fight. Together, we can sustain. Together, we can win. Thank you so much.